So CRJ 230, we move on to week number 6. And um, as we continue to build, this week we're going to focus on cross-examination, impeachment, and police officer testimony. There's documents, 3 documents that I ask you to read on each of those topics: cross-examination, impeachment, and police officer testimony. If you haven't read those documents before listening to this guide or watching this guide, pause, go back and do that. You need to read those documents. Remember, it's week 6. You haven't had to buy a textbook, some $200 textbook for this course. You're getting this part of the course for free. It's not costing anything, but I ask you to read those documents, typically short documents, and a lot less than the textbook would be, for a reason. It gives you that base knowledge to understand what I'm going to give you in this guide. Now, while we focused on credibility of witnesses, and that's something we always focus on, and we've talked about this several times already in different contexts, for this week, I would like you to focus on credibility of police and preparing to testify. So you're looking for an Illinois criminal case that discusses at length an issue raised at trial regarding a witness's credibility as exemplified by impeachment of that witness. And cases in which police officers' credibility is attacked are the most educational for our purposes. So search for one of those cases and find and present one of those cases. Focus on the element for which that witness's credibility is attacked. And remember why witnesses can be attacked for their credibility or cross-examined on their credibility. And that doesn't mean that they're dishonest. Of course, that's a bad thing if they are. That's not the type of focus that we're generally talking about. It could be that their report was incomplete. They remember the census. Was a person actually able to see, hear, witness the things that they say they witnessed? Is there any holes in what they're talking about? Do they have a lack of memory of certain elements? All sorts of things. So that's what I would prefer you focus on, if you would. So we previously covered the foundation required for introducing a witness and what we search for and hope to present in the form of a competent witness. We've talked about the competent witness. So now the foundation has been laid. We hope the witness is competent. We put that witness on the witness stand and you've determined their credibility. Now, hopefully you've looked at their credibility before, if you're putting them on the witness stand, before you ever put them on the witness stand. It's one of the observations that we as lawyers and paralegals should make. It's an observation that those of you going into policing should make when you're talking to someone, a person in society, a witness to something. Are they credible? There's an Illinois pattern jury instruction titled, "The jury is a sole judge of the believability of witnesses." That's an instruction that the judge gives a jury in a jury trial in Illinois. It provides that that only the jury is the judge of believability. So credibility is akin to believability. And the weight given to testimony of each witness is the jury's purview. Juries are to consider the person's ability and opportunity to observe, their age, their memory, their mannerisms while testifying, the things that go to credibility. In addition, any interest, bias, or prejudice can be considered. The Illinois instruction also allows that the jury can consider the reasonableness of the testimony considered in light of all the evidence in the case. Finally, Illinois references the defendant, and should the defendant take the witness stand, the jury is instructed by the judge that the defendant's testimony is to be viewed in the same manner as any other witness. Let's break that down a little bit. Okay, so a jury can consider a witness's ability to observe. Do they have corrected vision? Did they have their glasses on at the time of the incident? Did they have the contacts in at the time of the incident? Where were they in relation to the incident? Was there anything obstructing their view, their ability to observe? Their age, I guess as I get older, maybe that goes in both directions, but typically we think of their age as a capacity sort of situation, typically with a younger witness, a child. But it could also be with someone who's older, leading to the next one, memory. Now, we all have a different type of or ability to remember things. Some of you may remember things, vividly, photographically. If I'm, when I used to take depositions and statements from people, I can play that back in my head almost like a video. I still do that today as I'm not taking those things anymore, but I hear cases, municipal cases. And sometimes I have people who come back on that same case or come with other cases that are related, or they do the same thing over and over. So they have to come and face me to find out what their penalty is going to be. And I can recall that last time that they appeared before me in court, in hearing. And so I have that ability. I don't necessarily have some other abilities that some people may have. We all have a varying degree of memory. It may be dependent on age. It may just be dependent on ability, on things that you've developed as your skill. There's certain skills if you're going to do investigations or you're going to do any trial work or you're going to be a lawyer or paralegal working in litigation that I'd suggest that you would adopt. There's certain things that you would work on that you'd want to focus on. I think I mentioned those of you in policing, one of the tips that I had we had a guest speaker who was a police officer who I, eventually became one of my mentors, and he urged us to develop our peripheral vision. What's your peripheral vision? Your peripheral vision is, if I'm looking at you right now, can I see this map of St. Croix to my left? Yes, I can. Can I see my chair over there on my little, teaching station for my Zoom classes, my scheduled classes? Yes, I can. Was I always able to do that? No. And when he told me that, I was still playing basketball, college basketball, and I started working on it. And it benefited me there big time because I wasn't exactly a high-flying scorer, but I could move laterally. So to play defense, you're going to try to get by me over here. When I'm guarding this guy, I can slide. I can see you coming. It benefited me later, when I got into policing. Not a lot of benefit to that in the courtroom, but, I could probably name some times when I'm looking at the witness on the witness stand and the jury's over here to my left, and I picked up a reaction and was able to turn to that reaction. So there's skills for your memory, for your observation, things that you can develop. Well, other people have developed those either naturally or they've worked on them. Mannerisms. My paralegal students, especially those who've had me for civil litigation, know we talk a lot about active listening. I've talked about that a little bit in this course. If we were face to face right now having this conversation, my eyes are going to be locked on you when you're speaking. My eyes are going to be locked on your eyes. My eyes are going to be looking at your mannerisms, at your hesitations, the movement of your mouth, Did you pull back on something you were going to say? Did you hesitate on something you're going to say? Did your eyes dart from my eyes on something you said? You know, there's different articles and people, experts you can look to, but those are tells in my experience. Active listening will allow you to assess the credibility of someone. The jury can assess the credibility of someone on the witness stand based on those same mannerisms, those same reactions. In addition, interest. Do they have an interest in the case or the outcome or a person involved in the case? That's relevant. They have a bias against one or the other side. That's relevant. Are they prejudiced against one or the other sides of the case or people involved in the case? Are they, all police are bad? Have they said that? Were they willing to say that on the witness stand? That shows some bias, prejudice. You can go the opposite way too, right? But you get my meaning. So that's what the instruction says can be considered in believability or credibility. It also says the reasonableness of the testimony. Now, someone could be very good at looking you in the eye and telling you a complete fabricated story. If that story doesn't seem reasonable, your logical mind will start to break it apart. The jury can do the same thing. So even with all those other things checked off, is the story reasonable? Okay, that's what the Illinois instruction says. The federal jury instruction on credibility states that the jury may believe everything a witness says or part of it or none of it. I apologize for my dog in the background. Somebody is obviously out shoveling the massive amount of snow we got. So in the federal court, the jury can consider part of it, none of it, okay, or everything. That instruction says that the jury should take into account the witness's opportunity and ability to see or hear. It's the same as observe in Illinois, right? Or know the things that he or she testifies about. They have a reason to have knowledge of these things. It also talks about memory, the manner while testifying, their interest, their bias, their prejudice in the outcome of the case, and evidence that contradicts that witness's testimony. It also mentions reasonableness of their testimony in light of the evidence and any other factors that bear on believability. So credibility, believability. Are they believable? For all those elements can be considered to determine if you or anybody on the witness stand is believable. So state or federal court, the instructions are consistent and provide the elements you'll see at issue in the cases that you're going to find and present this week. The issues that are going to come up somewhere within those elements. Somebody questions someone's memory, their opportunity to observe, to see, hear, the reasonableness of what they're talking about, the manner of their testimony, things that they may have done on the stand. You'll see examples of all that in the spectrum of cases that all of you will find and then present. For this week, in your reading assignments, I added an emphasis on the credibility of police officers as witness. I did this for selfish reasons. Disclosing my interest and bias. I teach students who want to become police officers. I was a fire and police commissioner for several years, hiring, promoting, disciplining fire and police officers. I'm a municipal hearing officer. I take testimony from police officers, many of those individuals, my graduates. I also teach paralegal students who will break down reports, statements, and assess the credibility of potential witnesses in criminal and civil cases, to include police officers. I started out my career in that area, my post-college career, actually before college was all completely over, but I have a degree in police science, a degree in criminal justice, and then my law degree. It's important to me. I always want my students and my former students to do well in employment. I want police to be credible. I think we all should want police to be credible, believable, to write good reports, to prepare before they come to testify, which always drives me nuts. They haven't even looked at their report, especially if they have me for class. I want them to be credible, believable. I want the reports to be well written without holes in it. I want the reports to be reviewed before they come to testify. And I want them to testify under oath truthfully, with clarity, to testify well. I want them to be able to withstand cross-examination, to be believable. So I introduced these expectations as early as the Intro to Criminal Justice course when I teach that course. I want all of my students to work in their fields ethically, honestly, and to do the best they possibly can, to the best of their ability. And if they can't, I want them to voluntarily move on from these careers, because there's no room for those people here. If you aren't going to approach this in that manner and work to always be truthful and believable, complete in all of your efforts, does that mean you won't make a mistake? Absolutely does not. But when you make that mistake, you can own it and you can move on from it. So, as you research and break down and discuss cases this week, pay attention to the various examples. These cases this week are going to offer a lot in the direction of your future career. Whether you're going into law enforcement, whether you're going to any other criminal justice related field, whether you're going to go to law school, whether you're going to be a paralegal for a lawyer, there's a lot to gain this week. So read the articles, take your time and find a good case. Make sure it's a unique case. You can claim your case. Do a good job of writing up your summary to include the facts as to why the credibility of that police officer, hopefully you find a police officer case, why that credibility was questioned, and be very specific and clear. And then check back in, not only to read the summaries of your fellow classmates, because there should be a nice little example or spectrum of examples that will be interesting, but also to review the comments they make about your case, and especially if they ask questions. This should be an interesting week. I know I'm looking forward to see what you find, because, as we've discovered, new cases come out every day. I teach a wide spectrum of the law, from divorce to, wills, trusts, and estates, to administrative law topics. So constitutional law, criminal law, civil law. I can't keep up on all those things. I'm as interested in and learn as much as you're going to learn. So I appreciate that. Stay safe, stay well. If you need me, you know where to find me.